If you believe in freedom of speech, you believe in freedom of speech for the views you don't like. Good evening and welcome. This is Face the Nation. Our topic of discussion today is slippery slope of the Online Safety Act. To discuss all this and more, we've invited three guests to our studios this evening as well. Dr. Gehan Gunatilaka, Commissioner of the Human Rights Commission of Sri Lanka, joins us on the show tonight, alongside with Attorney at Law Bhavani Fonseca, Senior Researcher, Centre for Policy Alternatives, as well as Asela Waidyalankara, Cyber Security Expert. To pose questions from our panelists, on to my immediate right is Nadeem Majid, and on to my immediate left is Niresh Lethambi, Consultant English News Director at Newsfirst. You too can join in as far as the conversation is concerned. WhatsApp your messages to 076 656 5353. The number once again, 076 656 5353. Now, the latest development with regard to the Online Safety Act is that the Online Safety Act has been gazetted under the Ministry of Public Security by a special gazette notification by President Ranil Wickremesinghe. Let's get the ball rolling with Dr. Gehan Gunatilaka, Commissioner of the Human Rights Commission of Sri Lanka. What are your thoughts on the Online Safety Act?
So, I think it's an important thing to remember that criticism can come towards the Act because of two main reasons. One is the text of the Act, and many people from a variety of industries, variety of sectors, have raised concerns with respect to the substance, the text of the Act. The second line of concern has nothing to do with the text of the Act. It has everything to do with the institutions that will be responsible for enforcing the Act. And I think it's important to also spend some time focusing on that problem, because we do have laws that are also modeled on the best practice. Right now, we're all scrambling to improve this Act and make it a internationally acceptable Act. But we already have some acts like that. The ICCPR Act, for example, modeled on the International Covenant on Civil and Political Rights. Many would argue that it is a sort of best practice sort of piece of legislation. Now, it has been the subject of major controversy because of the way it is actually enforced in practice. So it's not really just about the text. It's also about the institutions that are responsible for enforcing the text and whether we can trust those institutions to act in good faith. And if you look at the ICCPR Act, there's a lot of concern that the ICCPR Act has not been enforced in good faith. It is designed to criminalize incitement to violence, but it is used in practice as a blasphemy law. And even the Supreme Court recently observed that it is not a blasphemy law. So this is a classic example of a good law being applied in bad faith. And I think the concern here is not so much about the text of the Online Safety Bill and what it might become with a spate of amendments. It's the fact that whatever that law might look like, there is a serious risk that it will be enforced in bad faith. And we need to think about institutional reform before legal reform.
So, Gehan, very quickly, on the 2nd of October 2023, the Human Rights Commission of Sri Lanka issued a statement stating that the government should revise the recently gazetted Online Safety Bill and you all make some recommendations. Now, this bill has been enacted into law. Why is the Human Rights Commission of Sri Lanka silent?
I don't think we've been silent at all.
You've been very active on Twitter, I've seen that, but as a commission, have you all been active on advocating
I think we would stand by the first statement that we made. And if you look at the prefacing of the observations on the bill, what I just said was precisely what the Commission said, that it is not really about just the text. We shouldn't be rushing through with these laws without focusing on institutional reform. And we, in fact, took the example of the ICCPR Act in that statement we issued on the 2nd of October. I think we stand by that. The thing is, our role is confined to advising the government on improving laws to be compliant with the fundamental rights chapter of the Constitution. Then this was done on the 2nd of October. On the 3rd of October, the bill was placed on the order paper. And then several people, several citizens challenged the bill before the Supreme Court. And then it gets confusing if one institution comments on it while another institution is scrutinizing the law.
But what is the position of the Human Rights Commission of Sri Lanka on the Act itself now?
So I can't speak for the Human Rights Commission of Sri Lanka as an individual, but the Human Rights Commission of Sri Lanka will be issuing a statement reiterating precisely what those concerns are. That essentially, we have to ensure that the Act complies with the Supreme Court's determination, because the Supreme Court is the final authority on the constitutionality of any law. Any bill that is placed on the order paper can be challenged before the Supreme Court, and that is the final authority. Now, if the final authority has issued a determination calling for the amendment of more than 30 clauses, calling for new sections to be brought in to ensure that this bill is compliant with the Constitution, then that has to be complied with. If not, then the bill has to be passed with a special majority, right? So one of the two. You either go ahead with the Supreme Court's recommendations, or you pass the law with a special majority. So I think, I can't speak for the Human Rights Commission as an individual, but the Human Rights Commission's position will be made very clear along those lines in the coming days.
Gyan, what I want to understand is, the Human Rights Commission of Sri Lanka is the sole objective or the motivation of establishing the Human Rights Commission of Sri Lanka is to protect the rights of the citizens of the country, and you all have a big role to play. Do you see the rights of the people being taken away by this bill in question?
So it depends on how the bill is going to be enforced, right? If the bill is enforced to the absolute letter of the law, maybe not. But that's not the concern we've raised. The concern we've raised is in respect of the existing legislative context, the existing way in which laws are enforced. There's a real concern, because it doesn't matter what the text of the law is. You have the PTA, which has a horrible text, and many institutions, many actors have called for its reform. Then you have the ICCPR Act, which has a near perfect text. Both are subject to abuse. So is it just about the text, or is it also about institutions?
But do you agree that more can be done by a body like the Human Rights Commission of Sri Lanka in respect to this act in question, at least to take a proactive approach?
So what do you have in mind?
You're my panelist today, Gehan. I would love to express my opinions on this, but yeah. I want to pick your brain on this, because you are sitting as a commissioner of the Human Rights Commission of Sri Lanka.
Sure.
What must you all do? Because at the end of the day, people look up to organizations like.
No, certainly. I'm not at all avoiding or deflecting on the question. I think the Human Rights Commission's role here is to advise the government on how to ensure that a law is compliant with the Constitution, right? So that's the first thing we do. So if we weren't silent on that. The moment the bill was gazetted,
on the 2nd of October.
On
yes.
the 2nd of October, we made that statement. Now, ideally, these bills should be shared with the Human Rights Commission in advance, so we can actually perform that role
That
before.
was not done.
So that wasn't done. We had to scramble when the bill was gazetted to actually study the bill and then issue a statement before it was actually placed on the order paper, because we didn't want concurrent jurisdictions, to be invoked with respect to the same piece of legislation. I think that's the first thing. Now it's up to then the government to take that advice on board and incorporate some of that advice into the revisions of the bill. But quite apart from that, the Human Rights Commission mustn't be seen as a sole institution. It's part of an ecosystem. And that ecosystem has civil society in it. It has the Supreme Court, the highest court of the land, in it. And this ecosystem is important in terms of working together to provide the necessary feedback and criticism on a bill that will impact on the fundamental rights of the people, namely the freedom of expression.
So now we are all aware, Gihan, that this is an act. This is part of the law in Sri Lanka at the moment. Today we saw the manner in which how the president has issued a special gazette notification putting the Online Safety Act under the purview of the Ministry of Public Security as well. What are the repercussions people are going to have in the future if this act is implemented in totality?
So that is completely dependent on how the institutions that are entrusted with enforcing the act will act, right? If they act in good faith, that is one thing. If they act the same way they've been acting when it comes to a plethora of other laws, then there is a problem. So that is why I think we need to study history, we need to study how laws have been implemented in this country and predict how a new law would be implemented. And that is why we're raising these concerns. It's not just about the text of the law. It is about the institutions entrusted with enforcing the text.
So do you think that what we experienced a few years ago with the Aragalaya and how the people were moving about on social media expressing their views and opinions, if that happens now under the implementation of the Online Safety Act, will the people be in trouble?
Well, let's look at the definition of false statement. If you look at the interpretation clause, false statement, it says that the individual needs to either believe or know that the statement is false in order for the statement to be a false statement. Most of the offenses, I think about 95% of the offenses in that act requires false statement to be satisfied as an element. Now, if I were implementing this law in good faith, I would say that I need to be satisfied that you actually believe or know that the statement you're making is false in order for me to actually charge you. That's a very high threshold. So actually, individuals should not be afraid of this act if it is implemented in good faith. But then look at how the ICCPR Act is implemented. Incitement to violence. Since 2007, we've had this law on our statute books for 17 years. Has a single person who has actually incited violence in all the episodes of violence we've come across in the last decade or so been prosecuted or convicted? The answer is no. But several people have been charged for offending religion or for blasphemy. And the Supreme Court of this country has actually said that the ICCPR Act is routinely abused. So this is what I'm trying to say. It's not so much the text. We have to also fear the institutions.
Thank you very much, Dr. Gihangur, the Commissioner of the Human Rights Commission of Sri Lanka. I now move my attention towards, Attorney at Law Bhavani Fonseca, Senior Researcher, Center for Policy Alternatives. What are your thoughts on the Act itself, Bhavani?
So, Shamir, I think it's a very important topic considering what's happened today, but it's also not coming in a vacuum. I think that's something to factor in. We are at the present moment looking at a whole spate of laws where the government is trying to restrict rights. So it's not freedom of expression alone, other areas as well. Last week we were in the Supreme Court on the Anti-Terror Act, or the proposed Anti-Terror Act. There is the proposed Broadcasting Authority bill that's supposed to be coming sometime this year. There is supposed to be another law to possibly restrict civil society and NGOs. So there is this culture where I think the government feels they need to bring in new ways of restricting various forms of freedoms and civil liberties. And what's the impact is something to look at. Overall, with the OSA, I will say it's not just what we shouldn't just be looking at the act that has been passed. I think it sets a very bad precedent the way it also happened. So it's looking at the process in terms of in 5 months, the government brought in a law with very little discussion, debate, very little awareness in terms of what the implications are. And when there were challenges, unprecedented number, 45 challenges in the Supreme Court, the Supreme Court determination talks about 31 amendments. And we can go into some of these amendments because I think that's something very important to look at. But when you propose such a lot of amendments, that also suggests it's going to change the scope, the structure of the proposed law. Why was there no discussion at that time? Why did the government rush through something so quickly when citizens the few citizens who are aware of, raised concerns, said, look, this is a massive change. Why are you rushing this? International actors too raised concerns. The IT, the tech company, again, we can go into all of this. This was not just a few raising concerns. considering all of that, considering the fact that the Supreme Court, and I will say let's even look at the determination. I think, you know, how it has been brought in or wasn't brought in, that also needs to be looked at. All of that raises the issue that the process should have been much more inclusive. We've had examples in the past, like the Right to Information Act, the Data Protection Act, where it took years to bring in a law. Now, one may say, why do you take so much time? I mean, that can be debated, but the whole point is no one can say we didn't know this was happening. So in 5 months, a law is brought in. Ask the question from people, do you really know what this law means? What is it going to do? There will be very few who will say, yes, we know the whole gamut of this act. So that's one. The process needs to be questioned. What we now have, and considering what happened in the parliament and what's reported in the media, there seems to be also gaps in terms of what's in the act. So the Supreme Court determination specifies certain clauses that need to be amended if it's to be passed by a simple majority. Question is, was all that factored in? We issued a statement today and saying that several areas have not been brought into the act. That raises a constitutional issue. Can the parliament ignore the highest authority in terms of constitutionality, the Supreme Court, a determination where they provide for very specific recommendations? If it's not brought into the act, there is a constitutional issue, and that needs to be also looked at. So it's the process, the end product, and then finally what Gihan also said, the implementation of this also needs to be closely monitored. Now we're going to have a very powerful commission, and again we can go into it in the show in terms of the powers of the commission, but it's not just the commission. There is also going to be a very powerful minister who can appoint experts through this act. So one will say, okay, the commission may take some time to be set up. You know, it has to call for applications. That process may take a long time. But there is one minister who will have powers.
So, Bhavani, today issuing a statement that you all say that the Online Safety Act should be repealed. Has this happened before with any of the bills in Sri Lanka where an act has been passed and the government withdrew or repealed an act in question? So is this practical? Has it happened before?
The question is, why shouldn't it happen, Shamir? And the point is, this government has promised recovery in Sri Lanka, stability in Sri Lanka, reforms in Sri Lanka. The president today gave a throne speech about the economic dimension. Now, for economic prosperity, stability, we've heard this narrative before, you have to have the confidence. You have to show you can govern. Now, if you're passing a law which in the face of it seems to have inherent problems from its enactment to what's in it, and raising the whole issue of constitutionality, are you able to properly govern? So that's why we say repeal this, because the government for 5 months said this is being brought for the safety in terms of online safety. Yeah. So if it's online safety, the question is, why don't you do it properly?
So, Bhavani, if you look at the government itself, you saw the manner in which how the Minister of Public Security recently said that I am not ready to remain as a minister in this government if I am to listen to the international community. Now, this was after the Yuktiya program was criticized heavily by the United Nations. Now, can you expect the government to go ahead and repeal? It's like pouring water on a duck's back. It's not going to happen. So as Gihan mentioned before, the civil society probably now has to go to court. Is that on the cards at this point of time?
I think all options are on the table at the moment, Shamir, because I will say this is a very, very serious issue. And I'm thankful for you all for hosting this show, because it raises the issue of the legislature, the executive, the judiciary, the role of the Attorney General. Again, I think these are all things we should unpack in terms of separation of powers, who has powers to do what. I mean, the Speaker has also issued a statement talking about his role and basically saying he's not responsible for what happened in Parliament. Now, there are also examples from the past we can go to where even the present president has made speeches in terms of the role of the Attorney General, the role of the Speaker in all of this. Let's talk about this. But as citizens, it's very important for us to hold the government accountable. That accountability has led to a resignation of a cabinet minister. That didn't happen in a vacuum. There was pressure. Will that make a difference? We are yet to see. But if we all stay quiet, nothing's going to work. So it's important for all of us, those watching this show, to ask the hard questions.
Very quickly, Bhavani, before I move on to Asela, very quickly. Today we saw the online safety bill being gazetted under the Ministry of Public Security. You have a minister who is very much adamant on what he wants to achieve, what he wants to do. How dangerous is that?
Very dangerous. It's very dangerous, and that's why it's even more important for citizens, for civil society, for anyone who respects the rule of law and democracy to call these things out and hold these individuals accountable, and if it's needed, go to court, but do it using the democratic processes and means. I'm not saying use violence. There are ways you can challenge, there are ways you can critique, and we need to use all that to hold this government to account.
Thank you very much, Attorney Advocate Bhavani Fonseca, Senior Researcher, Center for Policy Alternatives. I now move my attention towards Asela Vaidya Lankara, a cybersecurity expert. Asela, I'm going to pose a question to you. I'm not going to open the floor for you for your thoughts, but I just want to ask you, why is that when many international organizations are voicing their concerns on the Online Safety Act, why is it that the private sector of Sri Lanka, you may name any organization, we have SLASCOM, we have the Ceylon Chamber of Commerce, we have the National Chamber of Exporters, we have so many organizations that are representing the private sector. Why are they silent?
Well, you bring up a very important question there in terms of advocacy and in terms of being very objective, especially when it comes to the tech industry. And I'll just pick up one point that Bhavani touched on, the process. Now, I was part of the Personal Data Protection Act, the process. I represented one of the industry bodies. We've had 9 rounds of consultation there. The very same tech companies that have given their reservations to this particular piece of legislation were part and parcel of that process. I recall, and I use this story, when the Act first came to be, the PDPA, there were some questionable clauses on there. And we had a very heart-to-heart conversation with the drafting committee, and I must really mention the drafting committee here. It was built up of legal professionals and the participation of the industry. It was a very transparent process. And I remember Meta, Google, those particular tech companies made those representations. There was a back and forth. And finally, we got to a piece of legislation in 2022. And mind you, this is the same parliament, which approved that piece of legislation. And the moment it was passed, I recall the European Union's Data Protection Authority sent out a statement saying it is a benchmark legislation. And this was the first in South Asia. Given the challenges we had in 2022, we were able to bring out a benchmark piece of legislation in Southeast Asia. And even India is still trying to, I think they're just finishing their process. Thailand is doing the same. So we have that sort of DNA in us. It's the same, for example, for the data cybersecurity bill, which we've had rounds of consultation on, which we're still waiting on. And if you are concerned about online safety, my argument to you is, why are we not discussing that? Because certainly that is also a very important piece of legislation in terms of technology. So I will pause there because I'm sure we can delve into it. And coming back to your original question, You know, I feel honestly that the private sector, especially the industry bodies, should be more vocal, because we cannot just expect civil society to carry this burden, because there is, I think we are now realizing there's an economic impact to this. There's the digital economy that is going to be impacted. Because don't forget, the very same companies that have expressed reservation for this particular piece of legislation, there are people depending on those same platforms as SMEs, as content creators, for their digital marketing, including politicians when the elections are coming. So all of those stakeholders will be impacted in some way or the other. I may not say that they will move out of the country, but they might introduce certain safeguards for themselves to ensure that they are reducing their legal risk with this particular
Is it about regulating social media, or is it about regulating media networks in the country?
Well, if you read the spirit of this particular piece of legislation and the inspiration it has taken, because some of them are copy-paste of the certain countries, even including the interpretations. I think the focus, the narrative was on online safety. And let me just take a moment. There is a problem statement there. For the last, well, since 2020, when the lockdown started and people had a spike in digital usage because of the lockdown, because of the movement restriction, we've seen reported cybercrime. I use that figure very firmly, reported cybercrime, because there's a huge quotient that is unreported. Reported cybercrime has tripled. So ostentatiously, there is a problem in terms of cybercrime, in terms of online safety. Now, for example, there was a study conducted by UNICEF, if I'm not mistaken. Only 3% of the women who faced online violence even come up and make a complaint. So going back to what Dr. Gehan said, the structural weaknesses there. Do we trust the structure? Do we trust the process? So there's a lot of questions that there's.
Who drafted this bill, in your opinion?
It is authorless. I think there was somebody who had raised an RTI, and there was some gentleman who identified, and very swiftly, if I'm not mistaken, they issued a statement saying they had nothing to do with it. Take that with, again, the Personal Data Protection Act, where there was a committee. Those people are known. They're from the industry. And we have a set date for implementation, 18th March 2025. So there was a time period given to prepare. There are organizations preparing right now. We have a cool-off period. People are preparing, and there's certainty in that piece of legislation. You take this, it's a tale of two cities.
Very quickly, Asela, there's contention with regard to the appointment of the members of the commission in question. Let's say hypothetically, you were appointed to the commission in question, Asela. What would be your role?
First of all, I refuse, because on a matter of principle. But certainly it goes back to what Dr. Gehan said. How would you implement these things? Because here you have the key stakeholders. And let's be frank. These are not companies.
Is it vague? My question is,
the vagueness itself is what the Asian Internet Coalition has emphasized on. They've called it unworkable, their words, not mine. The vagueness itself makes it impractical, even if you really wanted to.
Because some say you don't have to be an expert in law, or you don't have to be an expert in technology. You have to be a psychiatrist to understand.
You must be a clairvoyant. Because as Dr. Gehan very correctly said, how do you know the maker, I believe, Dr. Gehan, was the statement you said, as per the interpretation section. So how do you determine that, Shamir?
Right. Thank you very much, Asela Lanka, cybersecurity expert. Onto my immediate right, as I said before, is Nadim. Onto my immediate left is Niresh. I'm getting a lot of questions. Nadim, with your permission, I want to give you an opportunity, but I want to pose this question to Asela because we were on this subject already. So we're getting some questions, Asela, Gehan, and Bhavani. Brace yourself. But I'm pretty sure, because of the expertise that all three of you have, you all will be able to tackle these questions quite well. The OSP states that the Commission is vested with the authority to issue recommendations to ISPs and internet intermediaries mandating the removal of prohibited statements. But in the case of MNCs like Meta, this falls outside Sri Lanka's jurisdiction.
Precisely.
Do we have the authority to raid the Meta headquarters in California in order to retrieve evidence?
No, we don't. And that's the point I wanted to make about practicality. You have to understand, and there is a clause here on registration. Surely, are we to expect trillion-dollar corporations like Meta to set up offices here? No, they don't. And mind you, for a moment, I hate to be going into technology, but the servers of these particular organizations are not located in Sri Lanka. They're taking a very, very narrow view of how content can be moderated in these platforms. They're spread across the world, and just for a moment, think, if the servers are in a country or a jurisdiction, that data cannot be accessed, and there is provisions here for data access for identity reveal. How would they reconcile those challenges?
But Arcela, I mean, based on what we saw in the debate in Parliament, I don't think any of the MPs were thinking about server locations and international agreements.
There was somebody who did a compilation of it, and they said usually when a debate of this nature and a policy of this nature comes, Najib, you have words like cybersecurity, words data policy, data governance. Sad to say, I don't think those words were used.
On that, now we're already hearing from, in the media, there's an official from the Public Security Minister has been quoted that they've now, post-enactment, have had consultations with the big technology companies like Alphabet, Amazon, X, formerly Twitter, and that amendments are going to be presented to the Cabinet within a fortnight.
But why?
Yeah.
Again, I fall back to the example of the PDP.
In which case, why was it?
Exactly. 3 years of consultation, Najib. Back and forth. And I'll take one example. Section 26 of the PDP, when they started, they said all the data should reside in Sri Lanka. That is something we vehemently denied, and that is something all the tech companies vehemently denied, because the architecture of the internet states that you cannot have data localization. You can't. But the committee was open to that. The committee understood that, those constraints, and they made amendments. And right now, if you look at the PDPA section 26, it says only state sector, public sector data should be residing in data centers. That was a back and forth process. That was a 3-year process.
Yeah.
So, which is why I come back to the point.
And even having the cool off and the rollout.
Cool off period, and you have a roll off period. You have, it's in a
similar
stage
process that was followed even with the RTI Act and other benchmark legislation.
Exactly.
Dr. Gunatilaka, Gehan, you mentioned that there are two main reasons, right? One is the text of the Act and the institutions. It's interesting that you said that, look, if there's bona fides or good intentions on the part of the people implementing it, then, like with the ICCPR Act, it could be a good act. A similar sentiment was echoed by former provincial governor and attorney at law Maitri Gunaratne a couple of days ago on face-to-face when he was interviewed by Charlotte. But I have a contention there. I mean, any legislation that assumes bona fides on the part of the people tasked with implementing it, that can't be good legislation, right? I mean, that's very poorly thought out. Especially when that institution is the Public Security Ministry and the Sri Lanka Police.
That's exactly why I raised the point that our intention, our aim with the discourse in terms of criticizing this process, in terms of pushing back, in terms of advising, if it's the commission advising the government, our aim can't be to get a better piece of legislation. That's the point here. So I think you're hitting the nail on the head, because a better piece of legislation is not a benchmark or indicator of success. It's when we can actually trust the institutions. So that's a long-term project. That institutional reform project is a different project to this. And I think our grave error when it comes to reform in Sri Lanka is this assumption that some problem can be solved with a new law.
Through legislation.
It's constantly a recurring theme. There's a problem, new law. Actually, if you look at the problem online in terms of safety, there are lots of problems. And I don't think I can find the word phishing in this law. I can't find the word malware or spyware, denial of service attacks. None of these seem to be featuring. So when you think about online safety, and the Supreme Court determination actually makes this observation, particularly when it was commenting on the offense on wounding religious feelings, which is a old colonial offense in our penal code that was replicated in this law for some reason. When commenting on it and saying this doesn't seem to have anything to do with online safety, it goes on to mention, well, there are these other things that do have a lot to do with online safety, which seem to be omitted from the scope of this law. So I think we need to think a little bit more critically about whether these laws are serving the actual purpose in the first place. And if you want to have a conversation about online safety, I think applying the existing law in good faith is a good place to start.
Do you feel that this advice now as a, previously as an activist and an academic, and now as a, member of the state, let's say, not the government, as part of the independent commission, the Human Rights Commission, do you feel that a lot of your advice tends to fall on deaf ears?
No, I wouldn't say that. It depends a lot on individuals, it depends on institutions, it's a mixed bag. There are institutions that are responding well to advice. There are institutions that are responding less well. I mean, it all depends on who it is.
Exactly.
Now, you'll ask me the next question would be which institution.
Who's listening and who's not?
Who's listening and who's not? I'm not going to, I can't answer that question, obviously.
But Bhavani, I'd want to bring you in on this about trust in institutions, because it has been deteriorating not just under this administration, but even under the previous administration, the one before that, even the Yahapalana administration. We saw what they did with the Provincial Council Elections Amendment Act, where they turned a 3-page bill into a 60-page act. And it has also happened before that, where the cabinet has disregarded Supreme Court judgment from 2007 on the entitlements due to past presidents. What does this mean for, you were talking about, separation of powers, etc., and how we're in a sort of a crisis situation, but this has been going on for more than a couple of decades at least. We came very close to collapse. One would say that we are collapsing. Are we in the process of collapsing? Is the nature of the state itself collapsing?
I think it's a very fluid situation, let's put it that way. But I'm not as cynical as you are. I'm much more hopeful. And why I say that is, I think the citizen is much more engaged. The citizen is much more active, and that gives you hope. I mean, I think we have...
Speaking to different citizens then.
Yeah, but the fact that there are more asking questions, more coming to the court. I mean, for me, just in the last couple of years, seeing new faces coming to court, new faces in the public, new faces challenging, critiquing, writing, means there's great interest. That there was a level of complacency where citizens didn't think they could make a difference. The fact that many at this time are sending your questions on this program also shows there's a level of interest, because they're concerned as to how that could impact them. End of the day, I think if anything we can learn from 2022, 2023 is the fact that the economic crisis hit people in a different way to prior situations. It hit them hard and it hit them personally. And then now they're starting to go, well, we can't be complacent because we can't get to that situation.
But is it a case of too little too late? Because the government is now armed with this piece of legislation that it can use very easily to stifle dissent.
They can bring other laws as well. But I mean, the whole point is, what is it that we do to stop it, to review, to challenge? And the fact that these programs, I mean, you've been having this, I think, for the last 5 months, using these kind of spaces to engage is also very important. Now, does it mean we get it all right? Of course not. We feel it's going to take a long time. But the fact that we are even having a conversation, the fact that when we put the statement out today saying repeal, the fact that many who didn't even ask this before are coming say, is that possible? What can we do now? That gives me hope. And we all need to explore new ways, as I said, democratically pushing back and challenging and holding these institutions to account. So, I mean, even I will look to Gihan and say, if the Human Rights Commission is not doing its job, we will ask the Human Rights Commission, why are you not doing the job? And I can say in the last few months, the Human Rights Commission, at least with these laws, have been very quick in responding, which gives us a handle, saying we can say, look, the Human Rights Commission says this. But, you know, if an institution that is meant to do their job is not doing their job, we need to, as citizens, also hold them to account.
But
So
at the same time, Bhavani, do you feel that, I mean, because you were saying, I mean, okay, all the options are on the table, and short of violent insurrection, you can go to court, you can protest, etc. But given that, I mean, there appears to be a pattern of acceleration in this impunity, lack of accountability when it comes to something as simple as adhering to Supreme Court judgments. Even if you look from 2007 to now, it's accelerating. You're saying people are more engaged, that people are more involved, that there's more civic, there's a sense of civic duty. But the results, I know I was told recently that if you're an activist, then you should forget about job satisfaction because you'll never achieve your goals. But at the same time, you should see, given that it's that this sort of sense of impunity is accelerating on the part of government on the one hand, shouldn't there be some results coming out from through that process, through filing petitions and going to court, etc.? Because are we seeing that?
I do see that. Okay, you'll say, look, you're saying you're being a bit naive here and saying, okay, what is this agents you're talking about when we are having a spate of laws being brought in? I'll flip it and say, look, a few years ago, I mean, both Gihan and I have been challenging these things. It's only a handful who would even be aware and challenge in court. It's the same faces you see. Now the court is full of new faces and new arguments. I mean, 8 days of listening to arguments on the Anti-Terrorism Act, it was refreshing to hear so many voices. Will that make a difference? I hope so. I mean, so one has to have hope. But can I also say, we also need to look at the fact that the Online Safety Act, it's an act now, it's not a bill. The act passed in 5 months. Now it's being gazetted. But the minister is still talking about bringing amendments. Now, why would they be talking about amendments if they were so confident this is done and dusted? They're still talking about amendments because they're feeling some pressure. Will that pressure work? I don't know. But we need to keep the pressure, because if you don't keep the pressure, I think it's going to be much more damaging.
But those amendments are being drawn up in consultation with tech giants, not with the public or with civic space. I don't know who the minister is talking. Well, that's what the public security official quoted is saying. They had consultations with tech giants, right? So it seems, because there are aspects to this act, right? There's one where, okay, it stifles freedom of expression. There's other where the technicalities of it, where, okay, where the data is stored, the agreements that you need with the tech giants, etc. It seems, based on, well, given that the consultations that they're having are with the tech giants, I suppose it's safe to assume that the amendments that they're going to bring in are going to be more to do with those technical side of things and less to do with the stifling of dissent and freedom of expression.
And that's also worrying in terms of why is it that they're only looking at one dimension and not the other? And that's the whole point is, I don't think you can fix this by bringing small amendments. This is a flawed law.
Yeah, because you can't be testing and trying and doing something based on a women fancy whenever you want to.
No.
And this is a part of the law of the country. You can't be testing and trying. That doesn't work, right, Bhavani?
I mean, I think we're agreeing on one thing, Shamir.
Yeah, so Bhavani, now we saw the manner in which how Member of Parliament Sumandiran on the online safety bill articulated that 13 amendments that the Supreme Court had required in the Online Safety Act had not been included, and that he requests the Speaker not to sign the act. And then a day before, the Speaker's office issues a clarification on the online safety bill and says that there is no opportunity to act in a manner that is not in accordance with a Supreme Court determination regarding a bill or in violation of the Constitution. Now I'm trying to figure out who is right and who is wrong. Is it MP Sumandiran, President's Council, who is wrong here, or is it the Speaker himself? Now, who are we to believe?
But Shamir, isn't that a moot point? Because now this is the law. And we only saw this a couple of days ago. It was a secret law where most people were concerned before, until it was gazetted a couple of days ago. and until then we didn't know. I wonder how many members of parliament even knew exactly what was in there. And in the end, here it is. And therefore, the public really never got a proper chance to study it, did they?
So can I just come in, and I think my two panelists also will have something to say here. It goes back to the role of institutions, what is their role, but also process. Now with this, very, very worrying thing is, after the determination went to the Supreme Court, did it go to the Sectoral Oversight Committee? Was there a report that came from the Sectoral Oversight Committee that was studied by the members of Parliament? Yeah. From what some members of the opposition have said, there was no report. There was a piece of paper. So that also questions the whole role of Parliament, committee systems that should be playing a role in lawmaking. If that didn't happen, if elected members of Parliament are not privy to a proposed law, 31 amendments, and whatever is missing, there is a whole issue that one needs to look at. That's one dimension. Now, the Speaker has to follow what the Supreme Court determination says. Parliament has to do it. If it's not followed, there is a constitutional crisis. Now, the problem here is, I think some who are in power, who are in powerful positions, disregard these institutions. That is a very worrying sign of the culture in this country. And we are in an economic crisis, we are in a governance crisis, because individuals think they can do anything they want to and disregard the Constitution. The Constitution is very clear. The Supreme Court looks into the constitutionality. The legislature then has a particular role. When you try to undermine these, there is a crisis point we are going to get to. And this is when we have an all-powerful executive president in this country who seems to be watching all of this and thinking, well, let these institutions fall apart in a way, because then there's no check on my office. But I also want to say this. The President in 2013 wrote an article in the Sunday Times, 2013, commenting on this process, commenting on the role of the Supreme Court, commenting on the role of the Speaker, commenting on the role of the Attorney General. That those positions have not changed. We have the same constitution. We should be following those examples. So there seems to be a slight amnesia
changed between being opposition leader and becoming president.
Possibly in 11 years, one changes positions.
Well, he was also prime minister when he introduced the, well, not he, but the Minister for Local Government introduced the Provincial Council Elections Act.
Possibly.
Amendment Act, right?
But the point here is, one very fundamental point is, this is just one example of how certain powers, certain individuals are tinkering with the Constitution, tinkering with the separation of powers, which will get to another crisis.
Bhavani, is this the same president who went to Lipton Circus and said that against the Rajapaksas that Facebook should not be banned? Is it the same president who was appointed through the Aragalaya a couple of years ago that you're talking about, Bhavan?
Well, we have only one president elected by Parliament that I'm aware of. But all I'm saying is, he's the executive president that was appointed by Parliament in 2022 with a lot of powers. That is something we all need to think about.
There's a question for Gehan. Let me take this question, Nadeem,
yes,
first. There's an international law principle called effects doctrine. So under this principle, a foreign party can be held accountable if the effect of an action by an overseas party could have a detrimental effect in Sri Lanka. Do you think our constitution has a provision to enact legislation with extraterritorial effect? If so, by which provision?
No, I mean, there is no prohibition on Parliament passing a law with extraterritorial effect. The question is whether it's workable. That's the real question to ask. And I think there is a common misconception about the role of the Supreme Court when it comes to vetting bills for their constitutionality. What the Supreme Court ends up doing is prescribing the procedure through which a bill can be enacted. That's what it does. So if the bill has absolutely no inconsistency with any constitutional provision, the court will say it can be passed with a simple majority. If it is inconsistent with some provisions of the Constitution, the court says this bill must be passed by a special majority. If it is inconsistent with further provisions that are entrenched, special provisions, you need a referendum as well. So let's not forget what the conclusion of the Supreme Court was when it came to the online safety bill. It was quite simply that this bill must be passed by a special majority in Parliament because it identified 30 odd clauses that were inconsistent. So the bill can't be passed except with a special majority. Now, the only addition to that is if all those clauses are amended according to how the Supreme Court prescribes and recommends, then it may be passed with a simple majority. So you start from a very important premise. The bill requires a special majority. Now, if you ask yourself the question, tomorrow if there's a special law that is placed on the order paper, someone challenges it, it goes to court. Court doesn't say anything about amending the law, just says this bill is inconsistent with Article 12 of the Constitution and requires a special majority. Can Parliament pass that law except with a special majority? No. A simple majority means that law was never enacted, correct? So that is how we must use and see the online safety bill. If it falls short of the Supreme Court determination, the requirement is a special majority.
You're making an argument that this law has not been enacted.
I'm not making the argument. I'm just saying this is how you have to understand the role of the Supreme Court.
But those are grounds on which the enactment of this law can be challenged.
If you were to make the argument that there are provisions in this bill that are inconsistent with the Constitution and the Supreme Court required them to be changed in order to be passed with a simple majority, my argument is not that the law ceases to exist. My argument is that it required a special majority.
So I have the Supreme Court determination with me now.
Yes.
It says, we have examined the provision of the bill and of the opinion that the subject to the above, none of the provisions in the bill are inconsistent with the Constitution. Therefore, the bill can be passed by a simple majority in Parliament, subjected to an amendment stated above.
Yes,
the amendment that they're talking about is the clauses 3, 5, 7, 9, 11,
Those
12,
are the 31
13,
clauses.
31 clauses that require a special majority as required by Article 84(2) of the Constitution.
That's what I'm saying. Exactly what I'm saying.
But this did not happen.
So that's what you're saying, that it didn't happen.
Yeah.
So one could argue quite convincingly that this bill required a special majority in Parliament. Now go and look at the Hansard and see whether there was a special majority or not.
No, Gihan, let's get practical here.
Yeah.
Now this is, for all intents and purposes, gazetted. It's law. Okay. We're having the discussion whether it happened legally or not. Fine. But practically, what are the steps which can be taken to rectify this astonishing situation? Or maybe not so astonishing. Vani, you might be wanting to correct us there. What are the options? One is expect the governing party to repeal the law or to amend it. We can have some reservations on that. Apart from that, what else can be done? Can it be challenged in court? What's the practicality? Before people start getting arrested for putting posts up on Facebook or wherever.
So let me answer the final bit of your question or comment. I think it's important, very, very important, not to create a fear psychosis. That, oh my gosh, this bill has now become law and is an act, and we have to be careful about what we post online. I think that is important. Ultimately, the offences...
We shouldn't worry about it?
No, let me finish the point. Ultimately, the offences that have been put in this law are offences borrowed from the penal code, right? They're essentially the same words with the addition of false statement and then online location. So they're basically tinkering with existing law. So what was criminal yesterday continues to be criminal today in a new form. So I don't think anyone needs to be fearful of continuing to express their views and opinions and criticism online. So that's very important. And as media personnel, there's a responsibility here, not to create that fear psychosis. Because there's a responsibility to tell citizens and users, do not be afraid of voicing your opinion if you are confident that your opinion is legitimate. Because it's only if...
But Gihan,
yes,
this bill can interpret it the way that they want after commission is appointed.
So-
and you will
so
say
that is
not to-
exactly what I
you will
started with.
say-
No.
yeah, you will say, don't worry, there is nothing to worry, you can express your opinions, and this innocent boy
Until
or
the
man-
commission is appointed.
until the
That's what he's
commission is
saying.
appointed, and once the commission
So
is
this is
appointed,
exactly what I
this
started
innocent boy is going to be behind bars.
We are
this is what I
talking-
started with.
Yeah.
This is why I said that it doesn't matter what the text is, because that risk exists today and it existed before the 1st of February. People are being arrested for the statements they made online, for the most innocuous statements they made online already.
So then
Right.
why do we want this bill?
That's a good question. I can't answer that question.
Why do we need this bill? Now you're saying
I
why
wish
we
I could
will
answer that
discuss
question.
it.
I don't know what the answer to that question is.
So I'm getting a lot of questions today, so I'm trying to balance it out as much as possible, giving an opportunity to all three speakers. So now it's Asela's turn. Asela, we're talking about digitizing the country's economy. We're talking about attracting foreigners to the country. Just imagine if Google, Meta, X, LinkedIn, Bookings.com withdraw from the country, what's going to happen?
They don't have to withdraw from the country. And I'll give you an example of that, which is why this evening, I think the digital media collective, digital marketing agency of the country, the professionals, put out a statement. What they
Finally, at least some organization.
well, I'm here, aren't I?
Yeah.
So,
some organization are there. So some glimmer of hope.
actually, to its credit,
The big boys are silent. At least the
to its credit, and there's another point I need to pick up on. To its credit, Slascom, the British Computer Society, and FITIS, when the day the act was passed,
reactive approach. Very good. That's of course that's the way to go
basically
about.
put out a
Asela,
statement.
that's the way to go about. You know, you wait until the milk is spilled and then you take actions after that.
Something
Wonderful.
about
My
closing
God.
closing the stable door after the horses bullshit.
The
Yes.
statement.
They
But-
issued
but-
a collective statement.
No, very good. Asela, that's the way to go.
No,
That's how
no,
we should-
Shamir,
Once again,
you're getting
Amazing.
you're getting an amazing number of questions. I think that in itself is a clear indicator that people are worried.
Yes.
It's not about creating a fear psychosis. Now, when the Gazette was issued just a few hours ago, we and other media organizations, we sent out SMS alerts. That's our job. And most people get some kind of alert, and suddenly they are worried now because something is
So
is
could I
going on.
ask the media personnel here a question? What do you think is an offence today that wasn't an offence before the 2nd of February?
Precisely.
I mean,
But it's-
what are you afraid of?
Can I put it this
More than
way?
anything, greater
It's like
inconvenience.
a child with a new toy. Here's the new
That's
toy.
a good.
With
That's an
with
absolute.
the old
that-
toy, we
that is
knew what
con-
he'd do.
That is conceded.
Right?
That is conceded.
Yeah.
I think it is like, someone who has the threat of being harmed by a knife now has the threat of being harmed by a sword, right? So the threat already existed before the sword came into operation, but
But
it's a
also-
new toy. So I think that point I can
Also, this same child just
fatality
locked up
rate is higher.
56,000 people in the last 50 days. So
So Asela was saying about taking a reactive approach, and that's well and good. Yeah, Asela.
So coming back
I
to the
beg to differ on that.
yes.
Yeah, you're entitled for your own opinion. Yes, tell me, Asela.
Chat for another day, perhaps. But I'm coming back to the point of the impact on the digital economy. It cannot be. It probably, for example, listen, from organizations like Meta, they're trillion-dollar companies. Pulling out of Sri Lanka could be even an afterthought because we're talking about 10 million active users. It wouldn't even show up on their metrics, honestly. But the point is not that. They might consider, and they've actually said, it is an unworkable law. Their words, not mine. And they might have technical restrictions that they will throw up, which I fear would happen immediately. Now, for example, Right now, you can place ads, and this is immensely helpful for SMEs. You can place ads on Meta platforms like Instagram and Facebook, and in rupee terms, you can do that. And there are digital marketing agencies, you can pay them in rupees, and they can run the ads in dollars. Now, that is a feature that is being given to Sri Lanka. If they feel, given this weight of this act, some of the provisions are unworkable, they might roll some of those things back and say, you know what, the ads must be placed through Singapore. Now think what the impact would be to digital marketing spend on organizations. Think what would happen to digital marketing spend on SMEs. Now this is the knock-on effect that no one, and this is why we say things like this have to be policy considerations thought out very well. Because this is
we're all saying that major chambers have to come and express their opinions at least now about all this.
Well, I'm doing it. So
yeah.
coming back to that point.
Sir, coming back to the statement that was issued by AIC right after the statement was made by Minister Tiran Alas in Parliament with regard to getting the consent of the AIC with regard to the online safety bill. Despite our commitment to constructive collaboration, the AIC has not been privy to the proposed amendment to the bill. We stand by our position that the online safety bill in its current form is unworkable and would undermine potential growth and foreign direct investment into Sri Lanka's digital economy. Can you elaborate a little bit on this when you say foreign direct investment, when you speak about digital economy, what's the parallel that we're talking about? Because when we speak about foreign direct investment, we speak about hard cash.
Not necessarily. For example, I go back to the PDPA. The reason the PDPA was brought in was there was an obstacle for foreign direct investors to come into the country because Sri Lanka lacked a data protection framework. It's the same concern right now that foreign direct investors are saying because Sri Lanka lacks a constructive cybersecurity framework in terms of making sure digital assets and digital infrastructure is protected. It is the same concern that they're putting out here, and the government also has an ambitious plan by 2030 to have $15 billion in terms of a digital economy. Currently, it's about 4% of GDP. The point is this: those investments will come when the laws and the policies are consistent, transparent, and compatible to international law. Now, for example, the PDPA is compatible to international law. The Computer Crimes Act was recognized as compatible to international law, so much so that we are now a signatory to the Budapest Convention. We were one of the first few countries in Asia. We've signed the second optional protocol also, which includes ransomware. Now, these are the things we must focus on, and these institutional frameworks are good. But the point is this: where we will really hit a stumbling block. Imagine if investments coming into a data center. If there's legislation like this, if there are frictions like this for that investment can be taken anywhere else in the region which is more attractive. That is what we are saying in terms of the hit to a digital economy. I've explained to you what in terms of digital marketing spend would occur. I've explained to you in terms of foreign direct investment would occur. There's one more point. If you look at the IT BPO sector and their direct markets, the key markets that they service, which is the US, the European Union, the Nordic countries, these are the same countries that have expressed their reservations about this particular piece of legislation. Now, if there is a thought process that's something similar to the situation of a GSP Plus, there are barriers put to IT BPO firms to operate in those countries because of such regressive legislation. That would be a problem for those countries. And don't forget, this is a thrust sector in terms of economic recovery. I firmly believe the ICT sector is a thrust sector that will get us out of this economic quagmire sooner than later because of the growth momentum that we've had. We've had a 13% growth year on year from now, despite the challenge. 300% growth in the last decade in the IT BPO sector. Now, you have that. Then the laws and the policies must support that industry and let it grow. And I think that's where probably that question is coming from, the impact of the digital economy.
So, Bhavani, whether the process followed in Parliament in the second reading could be challenged under contempt of court since the opposition says 13 clauses were not included under the Supreme Court determination. Contempt of court law, which was passed on the 1st of February 1st of February, says under Article 15, the provision of the Act shall have effect notwithstanding anything to the contrary contained in any other written law, and accordingly, in the event of any inconsistency between the provisions of this Act and such other law, the provisions of the Act shall prevail. So, can someone challenge it in the court of law saying it's contempt of court?
I think there are people exploring legal challenges because of the various issues, and I'll say this, I think it's worth exploring what happens in the next couple of days and couple of weeks. One of the things I think we need to remember in Sri Lanka is we do not have post-enactment judicial review, and that's a problem. I feel the fact that we only have 2 weeks to challenge, and the point raised before is that citizens are left out of a process after the Supreme Court hearing. It all happens in court, in Parliament, and then we don't know. And as we saw with the online safety, the then bill, the debate, there was utter confusion. I don't think most members of Parliament knew what was going on. There were questions raised by some opposition members as to whether everything in the determination was factored in, and the role of the Attorney General has also been raised. So, can it be challenged? Let's see. This is a new area, but we do not have post-enactment review. So, how it's going to be played out is to be seen. This is uncharted territory in that sense. But again, I think these questions are important to ask and to explore everything possible. Now, some people will say, why are you calling for a repeal of a law when the government has pushed it through and now talking about amendments? Again, let's explore everything. I'm not saying shut anything down. So the whole process of this has been problematic. In a way, we've seen a lot of problematic laws being passed, challenged. I've never seen this kind of thing happen, where you have so many clauses that required an amendment, and then in Parliament, it's still unclear exactly what happened. You can ask members of Parliament, and some of them still won't know what happened. So I think this is again it's a new time in a way. And what the citizen does is going to be important. What the Supreme Court would do if there are challenges is also to be seen. But again, can I say this? We've also been in situation where Supreme Court has given orders and Parliament has looked at it and said this is a matter before Parliament. It's a matter within Parliament. So all those questions are also going to be raised, and that's why I say it's a new area.
Gyan, why is it that the government is so adamant in bringing bills that are affecting the democratic framework? Because right now we are a country that need foreign direct investment. We saw the manner in which how the United States government has heavily criticized the online safety bill. So we have to be aligned with other powerhouses in terms of the region and make sure that we are in line. But the anti-terrorism bill is going to come into play. The online safety bill has now been enacted as an act. This is coming under the Ministry of Public Security. The Minister of Public Security says that he does not want to listen to the UN or any other organization. He just wants to go ahead with his plan. What is happening?
So I can't speak for the government, obviously. It's anyone's guess as to what the government.
No, but what is the objectives? Yeah.
I can tell you what the ostensible objectives are, what it appears to be. When it comes to different laws, the objectives can differ. When it comes to the Anti-Terrorism Act, there's been a lot of pressure over the years for the repeal of the PTA, and then of course there's a debate as to whether it should be repealed full stop or whether it should be repealed and replaced with a new law. And the anti-terrorism bill is yet another attempt to replace the PTA with what is touted as a better law. But that comes also because there's a lot of pressure to do so, right? If you go back to GSP plus conditions, one of the conditions was that the PTA is replaced with a law that abides by or meets international standards. When it comes to the Online Safety Act, I have to confess I'm not quite certain about what the actual agenda is. Because if you look at a criminal law expansion, if that is the agenda, it's very questionable because they basically replicated existing law, right? So I don't think the criminal law has been expanded that much to actually add to online safety as an objective, because if that was the case, we would have a lot more offences that deal with certain types of fraud, certain types of practices that are common online.
But given when you look at the
Yes.
when you look at the evidence before you, based on the behavior of the actors in this legal drama, like I said before, you look at, I mean, there are post-enactment consultations that they're now having with tech giants.
May
looking at
I
run
just
damage.
chime in just a bit, because you did mention that you're just talking to the AIC only. The AIC, on its letter dated January 8th, reminded, unfortunately it's quite sad that Meta has to remind the government of Sri Lanka, because Meta itself has been complacent on certain accounts. And it says that it should be in line with international human rights commitments, and the bill should recognize and ensure protection and respect to human rights, including Sri Lanka's fundamental rights. And it reminded Sri Lanka of its international human rights commitments. This is not me saying it, this is private companies, tech giants.
But basically,
Tech giants outside Sri Lanka.
outside Sri Lanka, reminding Sri Lanka of its international human rights.
But when you look at, like I said, isn't it a fair assessment that the agenda here is stifling dissent and the freedom of expression?
You can say this. See, there is a fear around social media, a fear that doesn't extend, I think, to mainstream media, because mainstream media has been through the mill over the last few decades, right? There's been exceptional amount of repression. There have been journalists arrested, assaulted, disappeared, murdered. Mainstream media has been through a lot, and mainstream media has learned to self-censor also, right? Social media is a space that is much more chaotic, much more wild, much more free, and it's a feared space when you want or when you have your agenda to control the narrative, right? And this has been always seen by various governments, not just this government, as a space that needs to be brought within its control, right? So I think if you're looking at a broader agenda, this agenda didn't start 5 months ago. This agenda started way, way back in history, where social media became a phenomenon in which people could actually engage, criticize, dissent, oppose without much control. And I think a bill of this nature, even though, as I said before, it doesn't really expand our criminal law, it does create the impression, and this is going back to your point about people being worried, it creates an impression that there's now a new regime that can be used against them, and that it will have a vastly chilling effect, which is why I think it's important not to create a... Yes,
So what you're saying is that vastly chilling, that the new regime is essentially non-existent, that this bill, that this act isn't worth the paper that it's printed on.
No, I think it can be very powerful. I'm not saying that at all. I'm saying that a bill of this nature can be extremely powerful in signaling a new regime that can be used. And if you take our legacy of laws that have a particular text and are used...
The government is playing psyops with using legislation.
I mean, it's not just this government. Governments around the world will prefer to have legislation at its disposal, and it doesn't always need to use the legislation. The threat of the legislation does the job, and that is what we're dealing with. And that is why even today there is a responsibility to reassure users that they need to be able to express themselves.
So Dr. Gehan, we've had a lot of people talking about and expressing their opinions with regard to the online safety bill since this was tabled and was spoken about a few months ago, right, Nivesh? Probably in June, July, we start talking about the online safety bill. And many of them said there is a need to bring in a bill to protect the rights of the children. Is that something that the Human Rights Commission of Sri Lanka and civil rights organizations believe has to happen through a white paper, or is it something that is not on the cards?
So again, can we explore that question with some rigor? Is the National Child Protection Authority coming on record and saying there is a gap in the law and we need to fill it with a piece of legislation? If that is the case, we need to take it seriously and look at the relevant law
Because
and
I'm
strengthen
asking
it.
this question, why Dr. Gehan is, we saw several days ago on the 2nd of February 2024, Mark Zuckerberg, the CEO of Facebook, turned at a Senate hearing to address the parents of children exploited, bullied or driven to self-harm via social media. And he said, "I'm sorry for everything you've been through. No one should go through what you and your families have suffered. Efforts are being made industry-wide to protect children."
Let's go with what you're saying. How many clauses are
is
there?
what I'm
Yeah,
saying.
yeah.
This
Let's.
is what
I mean,
Mark
what you're asking. There are 57 clauses in this bill, right? There are 57 clauses. How many clauses deal with children? There's one clause that deal with children. So are you saying that because there's one clause that deals with children, the entire bill needs to be accepted as doing nothing but protecting children? No, if your intention is actually to strengthen the legal framework in terms of preventing child exploitation and child abuse online, then look at the law, look at the penal law and improve it and strengthen institutions in that respect as well. Don't put women and children, because women also have featured in this debate. Don't use them as human shields in your agenda to promote a particular law, right? Because actually that's a noble intention. No one can deny the fact that the law needs to be strengthened, institutions need to be strengthened to protect women and children from exploitation and online harm. But then this bill has to be really about that.
So this is
the text of the bill surely can't.
This bill, in your opinion, should be thrown out of the window.
Actually,
you're
Atila,
saying. No,
I've given
not
your
really, yeah.
experience in cybersecurity, I want to ask, does this bill do anything to improve the cybersecurity regime in Sri Lanka?
Absolutely not. And this question I asked before, why isn't the cybersecurity bill spoken of in the same breadth and intensity? But I'll just answer a question Shamir asked. We are a signatory to the Budapest Convention on Cybercrime. Pedophilia or child pedophilia in the internet space is covered under that particular international convention. Can you name me one instance where we use this particular legal instrument, international legal instrument, where we can go after cross-border suspects who are operating these child pedophilia rings, especially in the dark web? How many times have we used that particular
Atila,
legal
you're talking about the dark web. We can't find our former central bank governor who's in Singapore.
No, but I mean, just coming back to the question. You asked about child protection. I'm asking you back again. When we have an internationally accepted convention, which we are a party to, we can share digital evidence based on the strength of that legal instrument. When have we shared that?
So you're
used
talking about a state that uses @gmail.com and @yahoo.
This is exactly, and don't forget,
Like,
and this,
the email security is not high on the
let's
list, so I
don't get
don't
me even
think-
started. But the point is this, then let's talk about our strength of digital evidence, which is completely missed in this entire conversation. How competent are we in handling this digital evidence? How competent are we? How many digital forensics labs do we have? Accredited digital forensics labs, because I've worked with accredited digital forensics lab. There's certain degree of international standards and accreditation. The people doing that need to be trained. They need to be certified. There are specialized equipment you need to do to extract digital evidence and present it in a way it's
So
internationally
in
accepted.
short, the state is utterly incompetent to handle
Where
this.
are we not? Why are we not focusing on that?
So I have a question for Bhavani. I'm getting a lot of questions, and most of these questions are opinions. So I request our viewers to post questions rather than giving
But I think opinions are also good.
Good that I'm giving opinion.
Listen to the
Do they believe it's true though?
Our
As
viewers
long as
are
you
making
believe
it
your
count
opinion
before
is
this act comes into operation.
So Bhavani, we just celebrated the 76th Independence Day of Sri Lanka just a couple of days ago on the 4th of February with much pomp and pageantry. Are we really free as a nation? Because I get the feeling that 2010, 2011, when we were reporting on the war, post-war era, During the war also, 2008, 2009, there was a self-imposed censorship in the country as far as the mainstream media was concerned. And why do I get the feeling that this is something that the government is trying to do? Self-imposed censorship is coming to the limelight, is coming to the forte once again through this bill in question.
Well, I don't think it's self-imposed in that extent, because you have particular actors within the government, within the state apparatus, who are using powers to target, arrest, detain. Every day we get numbers in the so-called Yuktiya program, which is sending a chilling effect. You said yes, we had a whole tamasha on Sunday in Colombo, but at the same time, on the same day, we had people protesting, citizens of this country, protesting in the north, who were manhandled, who were dragged. I mean, there are images. Now, the fact that you have different shades of this coming out in the social media, it was reported in the social media. I don't think mainstream really carried it. At least in the print media, I didn't see it. When you have that coming out in the social media, do you think a government that wants to project a particular image is happy when that image is contested with other images that show a different side? And remember, I think everyone who was in the state structure in government in 2022 were surprised at how the citizens challenged a government that was at one point very popular and had to go home. And social media was a key factor in citizens voicing their opinion. So I think there is a definite fear, and there is different ways of trying to restrict one's expression, one's speech, one's mobilization. But again, I will say, all these things are being done, but people are also pushing back, and the government is feeling the pressure. That's why it shouldn't stop.
So, Dr. Gyan, you said that people should not worry just because this bill is in, the bill has now been enacted into an act. People still can express their opinions. Let's say,
I need to clarify that.
Yeah, okay.
I didn't say people shouldn't be worried. I said we should not make people worry.
Okay, right. So I have a question on those lines. So let me make it very simple, so it's easier for our viewers to understand. Let's say hypothetically, I as an individual, now this has come into an act, I put a post on Facebook saying that I want to hold a protest march against the government on this day. So please rally around. What's going to happen?
You
100%.
can't be, I mean, if you're asking my legal opinion as to whether you can be prosecuted under this law, absolutely not. Absolutely not. If you're asking for my estimation as to whether this law can be abused to arrest you, I don't know. Because we have had...
The answer could be yes.
Because
the answer could be yes.
The answer could be absolutely yes, because we've had so many instances of laws that have nothing to do with the subject matter.
So don't you think it is our role as a media to highlight that the people should be careful, because now this bill, this act is in play?
But then think of the logic of what you're saying. Any law can be used and abused, right?
But not like this again. Look at this law. What is this?
You're not correct, because the law, even yesterday, the law even before February 1st, could have been used and was abused and is abused against dissent. So this law is, as you quite rightly pointed out, just one extra tool in that
ammunition
arsenal, right? It's not that the risk wasn't existing before. The risk is now enhanced in some way because there's yet another one. But if I were to look at the provisions of this law, look at the specific definition of false statement, right? I'll read it out. False statement means a statement that is known or believed by its maker. You're the maker of the statement. You have to believe that something you're saying is false, or at least know that what you're saying is false, in order for you to be actually charged under this law. So that's a very high threshold. And any legal opinion on this law would produce the same result. You cannot be prosecuted for that kind of statement. But whether it is possible in the future, I
But
can't
more than
tell the future.
Maybe more than the prosecution, the inconvenience of it is the intention. Being
So
hauled
that is
before
an
court,
absolutely critical
going over months, maybe years sometimes.
Absolutely crucial point, and the ICCPR Act is the classic example. So many people are arrested under that law only to be released subsequently when the opinion is given by the Attorney General that this has nothing to do with the provisions of the law. You can't prosecute the person.
But
Please
sometimes
release.
it takes years for that opinion.
Sometimes it takes months of incarceration. So the punishment is already meted out, which is why you go back to the original point. It's not just about the text, it's about institutions. Can we trust our institutions?
Right.
We can't, is what you're saying.
I mean, if you look at the legacy of other laws, certainly not.
So
Certainly
the
not.
evidence seems to suggest that we can't trust it.
Yeah, I mean, that's exactly what we have been saying at the Commission as well.
We need to wrap up. Nadeem, Nilesh, any questions to the panelists? Right, done. Way forward, let's start off with Asela Vaidya, Lanka, a cybersecurity expert. What must the government do now? And in particular, Asela, I want to know from the perspective of the people, what must they do now? How careful must they be now? Should this worry them in the future? And should it worry tech companies who have been silent in Sri Lanka so far? Yeah.
Should it
They
worry
haven't
the
been
SMEs?
silent, actually. I must disagree with you. They haven't been silent, especially on this matter. They've been more vocal than most. And in fact, if you read that particular statement, they're well informed. And it's a pity when reading this and listening to the debate in Parliament, it's chalk and cheese. But certainly, the way forward, again, I come back to my previous point. We have a history, and especially in the technology legislation space, we have benchmark legally acceptable pieces of legislation. But that was done through quite an extensive consultative process. If this is, in fact, the problem statement you are going to solve, which is of online safety. There are ways to do it. There are technological safeguards, there are institutional safeguards, there are legal safeguards. We need to explore all that. And of course, the major stakeholder of this is the tech companies. You need to have a very constructive conversation with them in how they're going to help us, how they're going to make the process frictionless, how they're going to do takedowns very well, quickly.
Yeah, Asel, just a quick, I usually don't pose questions the final round, but I have to pose this question to you. Why is it that the large tech companies in Sri Lanka are silent on this?
Large tech companies.
Chambers, why are they silent? In your
Well, they're not silent. I mean, they have voiced their disapproval, and they've asked, if you look at all of the texts they've realized, they've put out, they've said that you need to have more consultation. See, they're going by perhaps what they're used to, which is the cybersecurity bill, the data protection bill, which had extensive rounds of consultation, extensive rounds of, and I recall sitting in one meeting where the chamber was there, SLASCOM was there, everybody was there to discuss the Personal Data Protection Act in 2021. This is before it was sent to Parliament, in how we are going to go about doing it. What is going to be the institutional, and mind you, the PDPA has a lot more investment quotient for companies. You have to appoint a chief executive level officer for data protection. You have to have technological safeguards in terms of implementing that particular piece of legislation. There's a lot they need to do. But then look at that. In terms of Supreme Court, I think there was one challenge, and it was never given leave to proceed. And look at the online safety bill. 44, Dr. Gahan, was the number.
45.
45. I stand corrected. It comes back to, for me, in my opinion, the consultative approach that you need to take, especially when it comes to technology-based policy legislation. Because this is not cut and dry like previous legislations. You have to consider all the technological aspects. I don't think they've looked at it. The way they've defined a bot, any API can be considered a bot because it's supposed to be doing something it's not supposed to be. It's a very wide and definition that can be misused from a technology point of view. Yeah. So this is what I want to highlight in terms of the consultative approach here, and I don't think anyone has picked that up. In terms of an expert taking the evidence, how are they going to handle that evidence and present it? In terms of handling digital evidence, because we have chain of custody in terms of digital forensics. Those are principles that have to be followed. Nothing is spoken about here. I again go back to the consultative approach. I again go back to the fact that there is a real and present danger to Sri Lanka's growing ICT BPO sector and digital economy if we don't address the weaknesses and have a more consultative, open, transparent approach when it comes to this type of legislation.
Do you think this piece of paper needs to be repealed in totality?
See, my worry is, and I think this is some criticism that's leveled for people who speak against this because of the way it's framed, that if you speak against this, you are against women and children, that you are for pedophilia, online pedophilia. And that is not the case. No one is saying that. And that you are for big tech companies and not holding them up to account. Don't forget, we had a golden opportunity and we actually missed that. When the Easter Sunday attacks came, there was a gap in how Meta responded to that particular incident in terms of hate speech online. We could have, similar to what Singapore had done, asked them to come and give an explanation as to why that wasn't done. That should have been done in 2019 if we were really serious about these type of things in terms of a policy perspective. We didn't. Why now? And if you're doing that, not in 5 months. Certainly not.
All right, thank you very much, Asela. Bhavani.
Well, Shamir, I'll say this, and we said it in a statement. This is the law as it stands, or what was passed in Parliament, is deeply problematic, and it needs to be repealed. We'll say that very clearly. Will the government do it? I don't think so. They're talking about amendments. Will that ever happen? I also don't know. Because there's a lot of promise about amendments. Actual follow-through is questionable. But you can't fix this law. I'll say that. 31 amendments meant you change the whole dimension of that proposed original bill. And there is an Article 78 in the Constitution that talks about you can't change the purpose of a bill in Parliament at committee stage. That is what this government tried to do. So, fundamental point, you cannot tinker with a very deeply flawed law, repeal it, do it properly, have the proper process, be transparent, be inclusive, and I welcome the fact this government, if it's genuine in terms of addressing safety issues of women and children, if they're genuinely interested, have that conversation, look at the data and do it properly. There are existing laws. Why not start with implementing that and go through the amendment process? You can have a two-track system. Is the present law actually fully implemented? No. That is a problem. So does bringing in a new law really address some of the structural problems? I don't think so. So the whole point is do it for the right reasons. It's not being done for the right reasons. On the face of it, the way it's being done, the rush manner with the way it's being done, the statements that are being made by the key actors leading this exercise raises the question, is the real purpose behind this in such a rush manner is to have something to target those who are going to be critical in an election year. And we need to, as citizens, very clearly push back on any effort by the government and other entities who try to control freedom of expression, thought, and all of that. And the Supreme Court has been very clear. You cannot have a state that is trying to assume the role of being a guardian of one's public mind. If that is the way this government is going to go, then we all need to be pushing back. That is very important. But I'll give the benefit of the doubt if the government is genuine in addressing safety issues, have that conversation. Not tinker with things that suit their narrative. So be transparent, be consultative, demonstrate to the public that genuinely interested and do it properly. If not, this is going to be a disaster that's not just going to end up with a bad law, it's going to end up in another crisis. And we've just coming from trying to recover from a governance crisis, we don't need further issues. So if this government is genuine in terms of recovery and stability and growth, this is not the way they should be doing it.
Thank you very much, Attorney Adla Bhavani Fonseca. Dr. Gehan Gunthurga.
Yeah, let me clarify, this is by no means the position of the Commission, and I'm just making observations as just an observer. I think it makes sense for the government, and we're talking about the government's next move, right, to have a moratorium on this law. Right? Obviously, the law has attracted controversy, not just domestically but internationally, and the first good faith measure should be to say, okay, we're not going to go forward until we have more discussion. And that's a fairly reasonable, sensible, common sense sort of approach to take whenever there is so much heat on something. So a moratorium, I think, is the first step. The second really needs to be, as all the panelists have said, a more consultative process where there's dialogue with all stakeholders, not just international but also local, local civil society, local tech companies, the private sector. I think a law that people can trust and people can put their confidence in will also be a law that is better enforced and that will actually work. Right? So right now you will have people resisting this law as opposed to accepting it. You want there to be an uptake when you have new legislation. The way you buy that uptake is getting the buy-in of the stakeholders. So I think a moratorium and then a more consultative process is common sense. And I hope that's the path that is taken.
Thank you very much, Dr. Gehan Gunadhilaka, Commissioner of the Human Rights Commission of Sri Lanka, Attorney at Law Bhavani Fonseca, Senior Researcher, Center for Policy Alternatives, Asila Vaidya Lankara, a cyber security expert. Thank you very much, Nadeem. Thank you very much, Nivesh, for joining us this evening on Face the Nation, and for you for posing questions from our panelists on the number 076-656-5353. We are delighted to take your questions to our panelists, and as I said before, we don't take opinions usually on the show, so henceforth I had to drop most of the opinions that you expressed via SMS. However, stay connected, stay with Face the Nation. We come on Wednesdays at 9:30 right after the news, and we will talk about the problems that matter to you. So I leave you tonight with a quote, as I always do. The right to think is the beginning of freedom, and speech must be protected from the government because speech is the beginning of thought. Take care and good night.